Now, this is the code of conduct for United States judges. It's not created by the Article 1 congressional branch. It's not created by the Article 2 executive branch. It's created by the Article 3 branch itself. These are its own rules for good behavior for judges. Are there things in here that these judges, including Judge Boasberg, appear to be engaged in that would qualify as bad behavior under their own code of conduct? I would suggest yes. Here's Canon 2 of that code of conduct, that judges should avoid even the appearance of impropriety. What is an appearance of impropriety? Well, that occurs when reasonable minds with knowledge of all the relevant circumstances disclosed by a reasonable inquiry would conclude that the judge's impartiality is impaired, that he can't be unbiased and impartial. He's got some conflict. It goes on, public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. A judge must avoid, this is a mandate, it's non-discretionary, all impropriety and appearance of impropriety. And that's not all. Here's Canon 3 of the Code of Conduct for U.S. judges. A judge shall disqualify himself, non-discretionary, a mandate. A judge shall disqualify himself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances in which the judge or the judge's spouse or a person related to either within the third degree of relationship, which certainly includes children and siblings, is known by the judge to have an interest that could be substantially affected by the outcome of the proceeding. Well, do these judges have that? In fact, many of them do. Many of them do because many of them have spouses and adult children and siblings who are financially dependent upon the deep state swamp NGOs that Trump is actively attacking in his effort to save our great nation. His wife, Elizabeth Manson, didn't take his last name, is a prolific Democrat donor and founder of an abortion NGO called Meadow Reproductive Health and Wellness. Her NGO received indirect grants from USAID and contributions from Soros-related NGOs. These are all sources of funding that Trump is cutting off. That'll negatively impact her financial circumstances. She's the wife of Judge Boasberg. Judge Boasberg's daughter, Catherine, works for Partners for Justice, a pro-illegal immigration NGO that defends illegal migrants, that provides them with resources, with housing, with medical care for illegal migrants in the U.S. Is this a conflict with Judge Boasberg issuing rulings in these TDA cases? And it doesn't stop there. Judge Boasberg's sister, the sister of the judge, is also a member of the deep state NGO swamp, works for a nonprofit. You ever look at the salaries that are paid out from these nonprofits? Hundreds of thousands of dollars. And of course, this is all being paid for by USAID money laundering enterprises, which again are being targeted by Trump for elimination as part of Trump's exercise of the American will, of the political will of the American people. Does none of this add up to the appearance of impropriety? I suggest that it does. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day Law of Self-Defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. Okay, so what's been going on with Judge Boasberg? He's involved with a number of these cases against Trump, most notably the Tren de Aragua cases. Trump has issued a Alien Enemies Act, proclamation identifying Tren de Aragua as a terrorist group that's engaged in predatory incursion into the U.S. for the purpose of destabilizing the U.S. government. This is, of course, a national security ruling, which is embodied exclusively in the presidential authority, the Article 2 executive authority, a little bit in the Article 1 legislative authority, Congress, but Congress, by passing the Alien Enemies Act into law, granted what little authority they had in this area to the president. So the president has as strong a position on this national security issue as he possibly could have. And these are political questions. They're not judicial questions. They're not actually subject to being settled by the Article 3 judicial branch, which pretends that's not true, and they're doing it anyway in the form of Judge Boasberg. He's enjoined President Trump from deporting the Tren de Aragua criminals, terrorists, under his Alien Enemies Act. Why we need more alien terrorists in America is uncertain to me, but nevertheless, the judge feels that that's what should be done. So some time ago, Congressman Gill from Texas issued a resolution for the impeachment of Judge Boasberg. And I'm not going to read the whole thing because impeachment requires 67 votes in the Senate, and the GOP does not have 67 votes. So the impeachment may be sending a message to some of these judges, I guess, but it's mostly political theater. It cannot happen without 67 votes in the Senate. So impeachment is not the right way to go here. The right way to go, in my opinion, is to remove these judges for engaging in bad behavior. The other federal offices, the congressmen, the president, the senators, they all have limits on their tenure. Now, those limits are set in terms of years for those officers. Congressmen have a 2-year term, then they must run for re-election. Presidents have a 4-year term, then they must run for re-election. Senators have a 6-year term, then they must run for re-election. And when we look at the Article 3 branch of government, the judicial branch, there is no tenure set in terms of years. And many people interpret that to mean, well, they must therefore have a forever appointment, a lifetime appointment. Now, of course, any federal officer's appointment can be prematurely terminated by impeachment, a majority of the House voting for impeachment, and conviction in the Senate by 67%. By 2/3, works out to 67% in the Senate because we happen to have 100 senators. That's convenient. But you don't need impeachment to remove a congressman at the end of his tenure, or a president or a senator. They have to be reelected or they're no longer in office. So there's both a limited tenure within the Constitution in addition to the process of impeachment. Well, there's a limited tenure for judges too. It is in fact not a lifetime, forever appointment. And we know this because Article 3 tells us this. Article 3 holds in Section 1 that the judges shall hold their offices during good behavior. Good behavior, meaning not bad behavior. This is a tenure limitation on judges serving in office, in addition to impeachment to terminate their tenure of office. Impeachment is found in Article 1. It's a congressional power. This is found in Article 3. It's a separate condition for terminating the tenure of a judge. And it's a lesser means of doing so, meaning it's not required that the judge be accused of committing a high crime or misdemeanor, as impeachment requires, and therefore the threshold for removal is lower as well. You're simply saying he's acting in bad behavior. Now, what is bad behavior? We've in fact never removed a judge under this provision before, but it exists for a reason. No word in the Constitution is there for no reason. That's a fundamental doctrine of constitutional interpretation. All the phrases mean something. They're not there for no purpose. So this means something as well. What does it mean? Well, we've never used it, so that makes it difficult to know. But certainly it's a threshold for removal that would be less than impeachment. Impeachment is the highest threshold. So I would suggest that removal for bad behavior would be the inverse of how these judges get approved in the first place, which is nomination by the president and then approval, advice, and consent by a mere majority of the Senate, 51 senators out of our 100. Well, bad behavior should be removable, perhaps at the suggestion of the president, and then removed by 51 votes in the Senate, which the GOP does have. Now, this is something I've been arguing for some time. This tweet is from me, of course. It was February 25th, but this is a later rendition of something I've been talking about for quite some time. Impeachment is too high a bar. You need 67 senators. We don't have 67 senators, but federal judges can also be removed from the bench for failing to serve during good behavior. In Article 3, Section 1, condition of employment under the Constitution, most of these activist judges are violating their own judicial branch code of conduct. They're violating their own code of conduct in various ways and are therefore violating the Constitution's serve during good behavior clause and can be fired for cause, and in that way be answerable to the political will of the American people. And that's a simple majority in the House and Senate, which we do have. Now, this is the code of conduct for United States judges. It's not created by the Article 1 congressional branch. It's not created by the Article 2 executive branch. It's created by the Article 3 branch itself. These are its own rules for good behavior for judges. So if Congress were to try to define bad behavior or the president were to try to define bad behavior, we might have a separation of powers doctrine violation at play. Certainly, that's what I would argue if I were defending one of these judges from such a claim. But you don't have a separation of powers issue if the bad behavior was defined by the Article 3 branch itself, as it does in its own code of conduct. So, are there things in here that these judges, including Judge Boasberg, appear to be engaged in that would qualify as bad behavior under their own code of conduct? I would suggest yes. For example, here's Canon 2 of that code of conduct, that judges should avoid even the appearance of impropriety. What is an appearance of impropriety? Well, that occurs when reasonable minds with knowledge of all the relevant circumstances disclosed by a reasonable inquiry would conclude that the judge's impartiality is impaired, that he can't be unbiased and impartial. He's got some conflict. It goes on, public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. A judge must avoid, this is a mandate, it's non-discretionary, all impropriety and appearance of impropriety. And that's not all. Here's Canon 3 of the Code of Conduct for U.S. judges. A judge shall disqualify himself, non-discretionary, a mandate. A judge shall disqualify himself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances in which the judge or the judge's spouse or a person related to either within the third degree of relationship, which certainly includes children and siblings, is known by the judge to have an interest that could be substantially affected by the outcome of the proceeding. Well, do these judges have that? In fact, many of them do. Many of them do because many of them have spouses and adult children and siblings who are financially dependent upon the deep state swamp NGOs that Trump is actively attacking in his effort to save our great nation from implosion. For example, his wife, Elizabeth Manson, didn't take his last name, is a prolific Democrat donor and founder of an abortion NGO called Meadow Reproductive Health and Wellness. Her NGO received indirect grants from USAID and contributions from Soros-related NGOs. These are all sources of funding that Trump is cutting off. That'll negatively impact her financial circumstances. She's the wife of Judge Boasberg. His household finances are being negatively impacted by Trump's policies. Does that not create an appearance of impropriety when he's issuing negative rulings against the president in a number of cases? Absolutely, it does. Again, we don't have to prove that these conflicts are impairing his impartiality. The mere appearance of impropriety is enough. And this is his wife, his own household finances. But it doesn't stop there, because we also have his daughter. Judge Boasberg's daughter, Catherine, works for Partners for Justice, a pro illegal immigration NGO that defends illegal migrants, that provides them with resources, with housing, with medical care for illegal migrants in the US. Is this a conflict with Judge Boasberg issuing rulings in these TDA cases under Trump's proclamation under the Alien Enemies Act involving the summary deportation of illegal migrants? And this falls within the canon that is an immediate family member who has an interest in illegal immigration matters. And it doesn't stop there. Judge Boasberg's sister, the sister of the judge, is also a member of the deep state NGO swamp, works for a nonprofit. You ever look at the salaries that are paid out from these nonprofits? Hundreds of thousands of dollars. And of course, this is all being paid for by USAID money laundering enterprises, which again are being targeted by Trump for elimination as part of Trump's exercise of the American will, of the political will of the American people. Does none of this add up to the appearance of impropriety? I suggest that it does. And that brings us to, we already talked about the impeachment articles filed by Representative Gill. Well, just a couple days ago, he also filed a resolution calling for the firing of Judge Boasberg for failing to serve during good behavior. Now, this is Representative Biggs, not Gill. Gill was the impeachment. This is Representative Biggs. Now, I'm sorry to say, this resolution is not drafted in as compelling a fashion as I would have liked to have seen. Frankly, it comes across to my eye as weak sauce. I think it's seeking removal for serving during bad behavior is something that ought to be pursued. But if you're going to throw a punch, you have to have your body weight behind it. And this is just not great work. So a House resolution for removing Judge Boasberg, Chief Judge of the United States District Court for the District of Columbia, for the failure to remain in good behavior pursuant to Section 1, Article 3 of the Constitution. So you'd think it'd be important to point out the various ways in which Judge Boasberg has been engaged in bad behavior, right? I mean, that's rather the point here. And that, unfortunately, is where I think this resolution falls short. I wish they had called me when they were drafting this, but there we go. So James Boasberg, Chief Judge of the United States District Court for the District of Columbia, should be removed for failing to maintain the standard of good behavior required of judges under Section 1, Article 3 of the Constitution. And the following article of removal should be exhibited in the U.S. Senate after the House approves it. What are the grounds? Abuse of power. Judge Boasberg, in violation of his oath of office, did knowingly and willingly use his judicial position to knowingly interfere with the president's constitutional prerogatives and enforcement of the rule of law, and he did it for political gain. The Constitution grants Congress the authority to create, eliminate, and regulate all federal courts inferior to the Supreme Court. That is true. Article 3, Section 1, the first sentence reads, the judicial power of the U.S. shall be vested in one Supreme Court. That's the one court actually created by Article 3, and in such inferior courts as the Congress may from time to time ordain and establish. So all the inferior courts, meaning every court other than the Supreme Court, the district trial courts, the federal courts of appeal, immigration courts, tax courts, bankruptcy courts, patent courts, all of these are creations of Congress. And they can create them and dissolve them and constrain them however they wish. Congress creates specialty courts like bankruptcy courts and specifically removes jurisdiction for those cases, for that subject matter, from the federal district trial courts. So Congress is free to define the jurisdiction of any of these courts as it wishes. And of course, these judges shall hold their offices during good behavior, thereby granting Congress the authority to remove a judge who fails to remain in good behavior. That has to be the consequence of that phrase, that tenure limitation, tenure, in Article 3, Section 1 of the Constitution. The Constitution grants the president broad and expansive powers over foreign policy and national security. Absolutely. The Supreme Court has ruled that the power to conduct foreign affairs is a political power, largely beyond the scope of judicial inquiry. So it's important to keep in mind, folks, these federal judges act as if they have unlimited authority to do whatever they want. That's not the case. Every federal court is a court of limited jurisdiction, limited by subject matter, as I just talked about. Federal district courts don't hear bankruptcy cases. Those go to the bankruptcy courts. They don't hear claims for contract disputes against the federal government. Those properly go to the Court of Claims. I say they don't hear those things, of course. They're not supposed to, but obviously they have been. They're not supposed to hear claims about allegedly improper firings of executive branch personnel. Those are supposed to go to the Merit Service Protection Board. Nevertheless, the courts are, of course, doing that as well, the federal district courts, improperly. Bad behavior. But these questions of national security and foreign policy are outside the judicial authority. These judges only have limited, not infinite, authority. Our founders did not create a nation in which we are dictated to. Every office in government is dictated to by unelected, tyrannical, black-robed, inferior district trial court judges. That's not our constitutional order. If it were, why would we need a Congress? Why would we need a president? The judges can just do it. And by the way, when you read the readings of the founders, the judicial branch was intended to be the weakest of the three branches of government. Congress was intended to be the strongest, hence Article 1, then the president, Article 2, then the judicial branch in Article 3. So the Constitution places foreign policy decisions by the president and Congress beyond the scope of review by the courts. That's correct. In 1798, Congress passed the Alien Enemies Act. I've already talked about this. Trump has issued a proclamation under the Alien Enemies Act to remove predatory incursions by a quasi-military arm of the Venezuelan government, Tren de Aragua. Now, any of us might feel free to disagree with the executive branch finding that Tren de Aragua is a quasi-military arm of the Venezuelan government, or that Tren de Aragua is engaged in a predatory incursion of the United States. We're all entitled to have our opinion, but the authority to make that determination for governmental purposes and policy is exclusively within the hands of the Article 2 executive branch president. Whatever power the Article 1 Congress had over that decision-making, it abdicated to the president by passing the Alien Enemies Act. And there is zero role for the judicial branch to have any say in coming to those national security conclusions and foreign policy conclusions. The judicial branch does not engage in politics. The judicial branch is limited to settling disputes of parties before it in explicitly apolitical process. It would be horrific if the judicial branch engaged in politics, which of course it's doing, because the judicial branch is largely unaccountable to the American people. Has been. Lifetime appointments is what we're supposed to believe. Can only be removed by impeachment is what we're supposed to believe. In our entire history, only 8 federal judges have been removed by impeachment. How many hundreds of congressmen and senators have been removed by de-election? And of course, presidents as well. That's what makes the Congress and the executive branch answerable to the will of the American people. They can be de-elected. A much more difficult process when dealing with the judicial branch. All the more reason for them not to be engaged in matters of politics and policy, because they are so removed from being held accountable to the political will of the American people. So Trump issued his proclamation designating TDA as targets of the Alien Enemies Act for summary apprehension and removal. We've covered this all at detail. The act gives the president sole authority to determine the manner of the enemy aliens' restraint and removal, as well as to establish any regulations necessary to ensure public safety. That's literally the language of the Alien Enemies Act. Trump issued that proclamation on March 15th that all Venezuelan citizens who are members of Tren de Aragua are liable to be apprehended and removed under the Alien Enemies Act due to the threat the organization poses to the United States and its clear entanglement with the government of Venezuela. So it's a quasi-state entity working with the government of Venezuela as part of Venezuela's strategy to destabilize American democracy through violence of action, human trafficking, drug dealing, murder, other bad things. The president declared that members of Tren de Aragua are ineligible for the benefits of Section 22 of the Act, meaning they don't get to get their affairs in order before they're deported and are liable to immediate apprehension and removal. He directed the Attorney General, Secretary of Homeland Security, to immediately begin doing this, despite the broad authority given by the Constitution to the president when conducting matters of foreign affairs and national security. James E. Boasberg knowingly interfered with the president's execution of foreign policy by ordering the return of members of a designated terrorist organization to the United States. To justify his action, Boasberg cited questions concerning the interpretation of certain words and phrases, which are intimately tied to the president's foreign policy powers and beyond the scope of review of the courts. In doing so, James Boasberg knowingly extended beyond the bounds of power of his office and unjustly interfered in the execution of foreign policy and national security for partisan purposes of halting the implementation of the president's foreign policy and political gain. Remember, Judge Boasberg's wife, daughter, sister are all members of the swamp opposed to President Trump's policies. So they certainly receive political gain from Trump's policies being thwarted. And they are immediately family members of Judge Boasberg, bringing them within the Code of Conduct for U.S. judges and the mandatory shall disqualify oneself as a judge in a case if immediate family members have an interest in the proceeding. Certainly his daughter clearly does, as she works for an NGO providing resources to illegal migrants. Accordingly, under the Good Behavior Clause, these actions of Judge Boasberg constitute misbehavior, render him liable for removal. He should be removed for failing to maintain good behavior in office and no longer be considered a judge of the United States. Now, earlier I said I found this thing to be weak. Where are all the references to the violation of the U.S. Code of Conduct for U.S. judges? The ones I just stepped us all through. The mandatory disqualification and the fact that the Code of Conduct is created by Article 3. So themselves defining what qualifies as bad behavior. He's clearly engaged in that. And none of that is mentioned in this resolution. I just don't get it. Why would you leave that stuff out? That's the clearest, least ambiguous measure of Judge Boasberg's engaging in bad behavior and failing the constitutional tenure requirement for judges to serve during good behavior. And there's not a word of it here. So I personally found that to be extremely disappointing. I really like the limited jurisdiction approach as well, because, as I mentioned earlier, these inferior federal courts are all creations of Congress, not of the Supreme Court. Congress decides when to create them, when to dissolve them. Congress decides what their jurisdiction is to be. And there is now a filing in the House intended to address some of what's going on here by constraining the jurisdiction of these federal courts. Now, there's a variety of ways in which jurisdiction can be constrained by Congress, and every federal court has constraints on its jurisdiction. So, for example, a typical federal district trial court will have territorial jurisdiction, limited territorial jurisdiction. In theory, they're not acting like they do, but they're only supposed to be dealing with matters that arise within their territory, within their circuit, not any case in the whole country. They also have limits on subject matter jurisdiction. As mentioned, Congress has carved out specific slices of jurisdiction and removed that jurisdiction from the federal district trial courts, bankruptcy court, immigration court, court of claims, federal court of claims for contract disputes against the government, or administrative processes in place of federal district court. Firing of federal employees, if there's a dispute, is supposed to go before the Merit Service Protection Board, not end up in federal district court. And of course, the specialty courts like immigration court, tax court, and so forth. These are all jurisdictional slices that have been stripped away from the federal district courts, reflecting that they have only the limited jurisdiction that Congress assigns to them. They can also have jurisdiction in other forms of their authority, like their ability to issue injunctions. An injunction, of course, is an order from the court telling someone to do or not do something. Typically, it's explicitly identified in procedure as an extraordinary remedy that ought not be normal. But of course, these activist federal courts have been making it very normal, particularly in the form of these temporary restraining orders and preliminary injunctions being issued against the Article 2 executive branch president in the exercise of his core and plenary powers, and on a national or even international scale, well beyond the limited territorial jurisdiction of any of these federal courts. So we have this bill now, House Bill 1526. This is a bill that's been introduced to limit the jurisdiction of the federal courts, particularly with respect to these rogue injunctions. This act may be cited as the No Rogue Rulings Act of 2025. In general, Chapter 85, Title 28, United States Code is amended by adding at the end of the following limitation and authority to provide injunctive relief. No U.S. District Court shall issue any order providing injunctive relief except in the case of such an order that is applicable only to limit the actions of a party to the case before the district court. So this is directly addressing this issue with Judge Boasberg, where he had 5 Tren de Aragua plaintiffs in front of him in his courtroom, and he, sua sponte, on his own initiative, decided to create a nationwide class of every Tren de Aragua person in the country who might fall within the scope of President Trump's proclamation of the Alien Enemies Act. So here they're saying no district trial court, federal district trial court, will have authority to issue an injunction beyond the scope of the parties actually before him. No creation of these national classes of people. If a case is brought by 2 or more states located in different circuits challenging an action of the executive branch, so the Article 2 executive branch president exercising his core and plenary powers under the Constitution, then the case shall be referred to a 3-judge panel chosen at random and not by the chief judge of the circuit. The 3-judge panel may issue an injunction that would otherwise be prohibited by the language we just saw and shall consider the interest of justice, the risk of irreparable harm to non-parties, and the preservation of the constitutional separation of powers. So a 3-judge panel, not just every one of the 733 individual judges, federal judges in our nation, including many that were supposedly nominated by President Biden, or at least nominated by whoever controlled Biden's auto pen. God knows who was actually ruling the executive branch for the last 4 years. I seriously question whether Joe Biden had any knowledge or awareness that some of these judges were being appointed in his name, many of whom were not born in America, many of whom issuing orders in these cases were raised to the bench only last year, just weeks or months ago, had never been judges before, appointed for clearly partisan purposes. Their entire history is left-wing, hardcore, progressive, woke DEI politics, and an appeal of an order granting or denying injunctive relief may lie to the circuit embracing the district or to the Supreme Court at the preference of the party. So the injunctions, when issued, would be immediately appealable to the Supreme Court, which of course would limit the time wasting and delay, which is the real purpose behind these TROs and injunctions. It's to strip away the momentum from President Trump's policies, which he is exercising in the pursuit of the will of the American people. So I think that's a good development. I think it should be pursued. Of course, I must say that talk is cheap. And so far, what I'm seeing is a great deal of cheap talk from Congress. It's about time for them to step up and do something. If we're relying on the 9 members of the US Supreme Court to save our nation, we've got a serious problem. And that includes saving our Second Amendment rights, saving our national body politic from illegal invasion by tens of millions of criminal migrants. 9 people on the Supreme Court are not going to do that, folks. Especially Chief Justice John Roberts is not going to do that. He doesn't perceive that as his job. The people who have to save our bacon are the president and the Congress. Those people who are most dependent on our political goodwill by how we vote for them. Now, of course, the whole voting system has been terribly compromised. Much of our voting now is completely illegitimate. Nevertheless, that's the system we have to play with. And if anyone's planning on the Supreme Court saving the nation's bacon, you need to rethink that position, because that's not what's going to happen. Not one bit.